Welcome everyone to this webinar on name, image, and likeness. My name is Ron Gaither, and I am a partner here at BakerHostetler. I'm also the co-chair of BakerHostetler Sports Practice. I'm presenting today with my partner, Elizabeth McCurrach, and associate Sydney Park, both of who are instrumental to our supporting our sports team. And just a quick intro for Libby. Libby is a partner in our New York office. She's also the co-chair of the sports industry team. Libby routinely counsels clients on all matters concerning sports gaming and gambling. And Libby has even drafted the framework for legislation in the state regarding gaming and gambling. So Sydney is an associate in our New York office. She is a member of the commercial litigation team, and she's also an instrumental member of the sports industry team. Sydney has authored a number of articles having to do with name, image, and likeness. And so she is one of our young experts in this area. So I hope today is instructional, informative, but also hope today is a fun CLE. And the reason I say fun is because Libby and Sydney had the extraordinarily smart idea of saying, hey, let's have a webinar in the middle of March Madness about name, image, and likeness. So I have to give them credit for this idea. And so let me go ahead and set the framework for our discussion today. When you think about the NCAA, you think about amateurism, but something that's also the 800-pound gorilla in the room is the amount of money generated through college sports and college athletics. Something to the tune that's reported that the NCAA may do about $1.28 billion for 2024, and approximately 980 million of that comes from March Madness. And so when we think about it, this is an extraordinarily lucrative industry and extraordinarily timing. And so let's kind of get into it. Oh, and by the way, if you have any questions you want to submit to us, the chat's open. We hope this is a fun dialogue that we get to engage in super, super fun industry, sports. And so we look forward to having this. So what is NIL? NIL stands for name, image, and likeness. We all probably know this at this point. And it allows student athletes to monetize their images and compensation for promoting products or services. And so when we think about it, you start thinking about this idea of young college athletes out there being able to finally generate income or revenue from their own name, image, likeness, their appearance. So I think this is going to be something that the panelists today, we discuss a little bit, maybe hotly contentious, but what NIL is not. NIL agreements are not meant to be pay for play. I'm going to interject my own commentary, which is we're getting pretty close. As you can see, Libby and Sydney laughing because this is something that I kind of harp on. When the NCAA announced it would allow student athletes NIL activities, it insisted the NCAA's foundational prohibition on pay for play and impermissible recruiting inducements, which remain essential to collegiate athletics, would remain in effect. Okay. But student athletes and others, as you can imagine, push through and use the legal system to push the lines. So let's briefly talk about who the key players are, and then we'll kind of open it up for some discussions with Libby and Sydney. The key players, of course, are the athletes, the student athletes who we all can name, we all can see, we all kind of root for, every Saturday. I'm a huge University of Oklahoma fan. My undergraduate and then law school at Vanderbilt. So college football is huge for me, not at Vandy. And so we talk about the schools. The schools are also key players in this. And the NCAA, who implements the policy for all members, schools to abide by. All right, and legislatures. All right, this is one of those, issues that we will see that they're starting to get some consensus as it relates to at least both sides of the aisles can at least come together and say to themselves that there may be some issues in college sports right now. And then collectives, Libby and I and Sydney, we will talk about collectives here shortly, and advertisers. So Forbes reported that advertisers spend on NIL deals $1.4 billion. And again, as you can imagine, this is extraordinary, although a fun topic area, fun industry, the amount of money that's being spent inside of collegiate sports is just absolutely astronomical. So this is Sydney's slide. Sydney chose Caitlin Clark, Jared McCain, and Angel Reese and Flau'jae Johnson as, some of the folks who are the student athletes who are receiving the lion's share of NIL deals. Sydney, you want to, speak on either of these student athletes?
Yeah, of course. As we know, as we're watching March Madness and cheering for the teams that we love and maybe cheering against the teams that we don't so much love, you can't help but notice in the commercial breaks, on your social media feeds, wherever you might consume media, you might see some familiar faces that you see on the court as well as off. One of the most well-recognized members of basketball, both in men's and women's, has been Caitlin Clark. We've seen her in State Farm. We saw her in the Nike ad just previously. She has really done an incredible job of utilizing her position on the Iowa women's basketball team to leverage a lot of those marketing opportunities. And she's provided a really interesting case study in terms of what are the possibilities for not only athletes in general, but for women athletes specifically. As we kind of talk about these key players, they're not only just individually really interesting, they're interesting as a collective in terms of what is this new class of young athletes who are in college and rising up through the ranks and ultimately likely going to be professionals? What does that look like for them? But on the other hand, what does it look like for other athletes who might not have any aspirations of becoming professionals? We were talking about this just before, that one of the Oakland three-point shooters who had an amazing game dropping a ton of threes on Kentucky, he got an NIL deal right off the bat, and he filmed a video right in his hotel lobby for TurboTax. And that was fantastic because so many people on social media were like, man, that future accountant is great at basketball. And there he was with an NIL deal that allowed him to cash in on his notoriety and his really 15 minutes of fame from his performance on the court. And so we see kind of these two buckets of student athletes that are, one, going to go on to professional, likely going to be having a lot more media deals and things like that. And then on the other hand, those other student athletes who are still dedicating the same amount of time to their teams, to their practice squads, and to their games, but might not be on the same professional trajectory as their counterparts. So this NIL discussion largely has to focus on those two different groups of athletes and how policies can best serve both of those different trajectories in a way that makes sense for them. And I do want to add that one of the really critical parts of this is not just the athletes themselves and the schools they attend. The legislators are also considering these issues on the whole. And as Ron mentioned, both state and federal legislators on both sides of the aisle are recognizing this larger issue with athletes and collegiate athletes specifically. Just this morning in my newsletter that I get on name, image, and likeness, 2 new states have added in different caveats to their state laws regarding name, image, and likeness for both collegiate athletes and high school athletes. So this is not just something that we see every few months or so. This is something that's happening on the daily and something that legislators are taking incredibly seriously. And we're going to see that a lot more as we see money being poured into things like March Madness and the start of football season.
Yeah, thank you for that, Sydney. Libby, what are your thoughts on one, this slide, but also just the current state of NIL, in particular, state law, federal law? What are your thoughts on that?
Well, I mean, right now everything's a bit of a mishmash in terms of the laws and where we're headed, and obviously all of these state laws are still in effect. It's a lot like all of the gambling laws. There's no uniformity, which obviously is a huge issue. And for everyone's grievances with the NCAA, they're not wrong that lack of uniformity and that patchwork is a problem. And it's a problem for schools with recruiting, no matter where they are, in terms of the vast differences in these laws. We talked about yesterday, this slide is really interesting in terms of the fact that with Caitlin and Angel and Flaujae, they're going to presumably go to the WNBA, where I think their starting contract is, $70,000. So it's going to be really interesting to see what happens and how this affects changes within these leagues too. And, whether this does lead to more enhanced compensation in some of these leagues where they're just in a different position than Jared, so because they're obviously very well known. I mean, Caitlin Clark, obviously her valuation dwarfs everybody else, and I would say in most of the commercials I saw during March Madness, everybody knows who she is, which is really to her benefit at this moment. But in terms of where we're headed legally, I think that's, a question. When we're talking about the legislators, we talked about this the other day. It's interesting when the NCAA was considering who to replace Mark Emmert, and they didn't go with, the commissioner of the Big Ten or, the commissioner of the SEC. They went with a politician. And somebody in Charlie Baker, somebody that I think they're hoping can build a coalition and get these legislators to work together and actually affect some change. I don't know if that's going to happen, but I read something recently where he actually gets to meet with, the senators themselves as opposed to their staff. So he personally thinks that's a good sign, but we'll see what happens.
Yeah, I think you're absolutely right, Libby. This idea that the issues related to college sports and the framework of college sports is literally on everyone's radar. Senators, the state houses, everyone has an interest and a concern as it relates to what's going to happen in college sports. So, and candidly, one of those huge issues is just simply collectives. And I don't want to use a pejorative term, booster, but they're boosters. So a collective is a large organization or an organization of boosters who come together and essentially generate funds or collect funds in order to distribute to student athletes. And collectives are, a huge, not issue, but a huge part of this dynamic as it relates to name, image, and likeness. And I'll just mention a couple of these collectives. We know about the Spire Sports Group. This group is out of Tennessee, and they're affiliated with the University of Tennessee. We'll talk a little bit about that case, a recent case filed by the Tennessee AG against the NCAA. And we'll talk about Division Street, which is a collective that is affiliated with the Oregon Ducks. And as you can imagine, in Oregon, which has a storied relationship with Phil Knight, founder of Nike, you can only imagine the power that particular collective has. And then we kind of talk about the 12th Man Fund affiliated with Texas A&M. And this is one of those funds, I mean, it's literally built into the name. We all know that Texas A&M, they champion their 12th man, and their collective, a collective that's affiliated with Texas A&M, literally has it in the name. But one of the collectives that we talked about as we were prepping for this particular webinar is the Crimson Collective, and it's affiliated with Utah. And if you follow collegiate sports, this is the collective that organized giving each football player at Utah a brand new Dodge Ram truck. And I was just blown away. Although these trucks are leases, these are still benefits under NIL that these student athletes are receiving. And each one of these trucks is valued at $61,000. And so I think keeping an eye on collectives and what collectives are doing on the ground is hugely important to any discussion on NIL.
Ron, I think something also important from this slide as well that I want to just bring up is the fact that what we're seeing in terms of the transfer portal is going to be so impacted by the influence of collectives. And I know we spoke about this yesterday as we were discussing kind of what we wanted to talk about. And it is really a critical question that schools and leagues and legislators and any policy has to take into account is what are we going to do when it comes to fairness in terms of lucrative collectives offering these kinds of large deals for athletes. Of course, athletes are going to want to go to the places where they have the best opportunities. So how do we address that in a way that makes sense, that is fair, and that still maintains that same competitive aspect that we all know and love for college sports?
Agreed. Libby, your thoughts?
Yeah, I think that the collectives, I think, raise such an interesting issue. And I think the word that you used, affiliated, is an important legal word with all of this, because I think the schools themselves would all tell you the collectives are separate. We work with them, but as we've seen, when they come under investigation, the school also comes under investigation too. It's not just the collective, as we saw in the Tennessee Aspire case, which we'll talk about later. But yeah, the collectives are a huge piece behind, all the new movement against the NCAA on the transfer portal as well, where to the extent people don't know, in college athletics, you're allowed one free transfer where you don't have to sit out. If you transfer a second time, technically under the NCAA rules, it's always been that you had a year of ineligibility where you had to sit out. And so that is now being challenged mostly because of these big money players that want to transfer again. And so it's a question of whether or not that's a restraint of trade. It really came to a head in West Virginia, which is where that case is pending right now.
Yeah, I think you're absolutely right, Libby. And one of the things that interests me is what is happening on the ground with these collectives. We need some vision into the collectives, how they move, how they operate. And we have a really good friend of our sports industry team, Mr. Darwin Wincher, who's on the ground as a consultant with collectives and with the students and with the athletic departments. And so I think he's going to be a valuable resource kind of going forward about what's happening on the ground with collectives. So how do we get here? It's not going to be a CLE without a little bit of law. So we'll talk about kind of like the history of name, image, and likeness. And it's this idea that question, should athletes be paid? And, just briefly, the NCAA has always maintained that amateurism and paying athletes, essentially the delineation between amateurism and professional sports. And that's just under fire at this point. I mean, that theory, that argument has been under fire for a while. And in 2019, Gavin Newsom signed into law the Fair Pay to Play Act. And this is in California. And essentially what it said, it did 3 or 4 things. One is, yes, student athletes should be able to monetize their name, image, and likeness. 2, it essentially said that, hey, there can't be any kind of retribution or penalty, punishment against student athletes who engage it. So we need to protect their scholarships. 3, and this is something unique to California, which is it allowed for student athletes to use agents. And that was, huge because Libby and I, we did one of the first name, image, and likeness deals about 2 or 3 years ago.
Pre-collectives, everything. Yeah, no.
Yeah.
It's really the Wild West, and it's crazy how far it's come even since then.
Well, absolutely. And the final piece of that particular legislation was this idea that if a student athlete does engage in a name, image, and likeness deal, it can't conflict with the university. The easiest example of that would be if this is a Nike or Adidas school, you can't wear Converse, so to speak. So you can't endorse those. So I'll have Libby and Sydney talk about, Alston and the Supreme Court.
Sure. And so this all came to a head really in 2021. And, before that, California was the first to sign this into law, but then a lot of states followed suit. And California actually had sort of a a sunset provision where it wasn't going to take effect until 2023. So it did give the NCAA and other states time to consider this and try and make their own laws and everything. And so a bunch of them did. And so, and it coalesced at the same time that this was coming up and came up to the Supreme Court. And so the Supreme Court overwhelmingly held that the NCAA cannot restrain these education-related benefits to athletes anymore. And it just set the stage for everything that we're seeing now. And so from the pressure of that, you know, the NCAA really had nowhere to go. They had to change their policy, both from the Supreme Court. They're getting it from everywhere, like the Supreme Court. There are so many other antitrust challenges percolating in so many lower courts. California has been traditionally where these things have been brought, but now we're seeing it in a lot of other states, actually, where they usually would come up right before Judge Claudia Wilken in California. And now, you know, it's more widespread than that. And it's a lot of AGs bringing these. I think they're very popular in some of these states, and we are in an election year as well. So in June 2021, the NCAA announced their interim policy that you can engage in NIL as long as it doesn't conflict with the law of the state of where your school is located. And since then, there's been some guidance, but they're still really always in the rulemaking posture with NIL. I think that they have been trying to figure this out since then, which leads us to January, and Sydney can talk about that.
Right. And even this rule is constantly being thrown in the air. In January 2024, the NCAA and its Division I counsel announced that it had a new policy regarding NIL, which would still ban inducements in recruiting and pay-for-play schemes. And this is critical to some of the cases that we'll be discussing in terms of where we are now. But enforcement of this rule is now up in the air, given a preliminary injunction in the state of Tennessee. And so the NCAA has suspended all of its enforcement in this regard. And this will be really interesting, given that the transfer portal opens once again in mid-April. So we'll have to see how that policy changes, what's going to happen in terms of how that case is going to affect the transfer portal, as well as how the case will affect the enforcement policies of the NCAA going forward when it comes to recruitment and inducements to playing for a certain school. All of this has kind of come to a head in the cases that we'll discuss soon in the next few slides.
Absolutely. And it has to be said that this, when the NCAA took Alston up to the Supreme Court, they virtually got smacked. I think Libby was very diplomatic to the NCAA, but that was a 9-0 decision.
Yeah, exactly. It was unanimous. On this court, it was unanimous.
Yeah, that's exactly right. And this court had a unanimous, decision, and Kavanaugh's concurrence essentially, called the NCAA a cartel as it related to student athletes and the treatment of student athletes. So we'll talk a little bit about the NCAA and Alston.
Right. So just diving a little bit into NCAA v. Alston, because this is really where so many of the legal challenges in the NIL policy was kind of born out of. As Libby mentioned, that this is really the inception point for a change in the NCAA policy and posture towards NIL and overall compensation for athletes, student athletes who are participating in collegiate sports. So the background of this case is largely that current and former student athletes sued the NCAA and 11 Division I conferences, alleging that the NCAA's limitations on compensation for athletic services violated Section 1 of the Sherman Act, which requires there to be some kind of agreement between a bunch of groups in restraint of trade. So following a bench trial, the district court granted partial relief for the student athletes. And what this meant was that it largely enjoined the rules that limited the NCAA's prohibition on education-related benefits, such as those for scholarships for graduates or vocational schools, payments for academic tutoring, and paid post-eligibility internships. This decision was affirmed by both the Ninth Circuit and the Supreme Court. As Ron and Libby mentioned, that was 9-0 at the Supreme Court level. And so what the NCAA postured as its major argument in support of its rules and prohibitions was that these rules are necessary to preserve amateurism, which has largely been the NCAA's calling card for college athletes, is that this is what differentiates us from pro sports, this is what differentiates us from the other leagues, is that this is about amateurism. And in order for us to be able to be the leagues that we are and be able to maintain that spirit of amateurism for college athletes, like these rules are necessary. And this actually was their argument because it really, for them, widened consumer choice by creating a product that could be unique from those professional sports. But as Ron has mentioned, we know that the colleges and the NCAA make a lot of money off of these athletes. And so when we think about amateurism, we have to consider that perhaps that theory of collegiate athletes and collegiate athletics has changed over the course of the NCAA's existence.
Yeah, and Libby, that's a question I'm going to pose to you. Has it changed this idea of amateurism, this idea that student athletes shouldn't be compensated? If you were to describe for the attendees like the ecosystem whereby once upon a time that was a valid theory to now, what do you think has changed about that theory and whether or not it's even plausible anymore?
Yeah, I mean, I think everything has changed. Historically, obviously, the NCAA has been around for a long time. And the member institutions who had athletic programs, it was an elitist system, and a student athlete wasn't supposed to need anything else. Obviously, they were, for the most part, all very privileged. And, this was just a consideration that never would have occurred to anyone as they were conceiving of some of these rules when they started out on the idea of amateurism. And obviously, everything, our culture has shifted in a major way. And so clearly a lot of student athletes and people who are athletically gifted, this is, how they're going to make good money, and, hopefully they'll go pro. But the thing about NIL that now takes this into account is that, and I think this has been the NCAA's argument for a long time, most of the student athletes are not going to go professional. And so, this is setting them up. They've always had the opinion, this is setting them up for, something that's not correct. They need to really focus on their education and, put everything else to the side. Whereas, now as we see, you're like, well, if any of us were in college and not athletes, we all could have been influencers and it wouldn't have run afoul of anything. Just being a student athlete, you would have been afoul of all these rules. So I think that things have shifted in such a dramatic way pretty quickly. But I think there's a reason we also chose March Madness as the time to do this webinar, because March Madness is really what shined a light on all of this too. That this is so much money that is exchanging hands. So, and none of it is going to any of these student athletes, outside of their scholarships that we're aware of. I think that, the Supreme Court with this Alston decision, it reminds me a little bit of, and reminded me at the time of the Adam Silver op-ed, a decade ago with gambling, saying, let's just bring it into the light. Let's just try, like, the system is what the system is now. We are not in this, early 20th century system anymore. Things have changed, times have changed, the needs of our student athletes have changed. And that's the sort of historical perspective, I think, on how we got to Alston. And, I think the NCAA had really never lost at this grand a level before. So I think that, I'm sure they were not expecting a 9-0 verdict when this went up.
Yeah, I agree 100% with you. And I just want to make sure that we mention or just talk about this, the reality of, we briefly talked about, the 1.28 billion that the NCAA will bring in this year. These TV rights deal valued at $980 some odd million for the extension, but also talk just the very highly visible salaries of college coaches. I'm going to pick on Clemson just for a little bit because Dabo Swinney has, said certain things as it relates to NIL, and then he's changed his tune. But a lot of that may have been driven by the fact that Dabo Swinney is set to make $10.8 million in 2024. And had Nick Saban continued to coach at Alabama, he was due to make, they say $11.4 million. The highest paid state employees are college coaches. And this idea that the student athletes don't get an opportunity to share in the revenue similar to the coaches and, others is just is inherent inequity that I think just the sheer success of collegiate sports has really been a catalyst for a lot of the change that we're actually seeing right now. Whenever my mother says in college sports, that seems unfair, you know the NCAA has a problem.
I saw a meme, Ron, about Nick Saban, him saying it was too hard to coach with the transfer portal, telling his wife, and somebody wrote, did they talk about it at their $17 million house or their $11 million beach house? Or like, where did they have this conversation?
Yeah, exactly. Or surrounded by his fleet of Ferrari. He has a collection of Ferraris as well. So
Yeah.
it's like, wow. So, but we have to talk about where do we go now and just what's going on. So, so we'll talk about the NCAA case.
So yes, so this is a big deal and probably the biggest one happening right now. There are obviously a lot of cases percolating. This actually involves a little bit of history that's probably helpful for people to understand why this is all happening in Tennessee and why Tennessee cares so much. But so the University of Tennessee has actually been under investigation the past few years because of what the NCAA, and I think most people would consider really flagrant pay for play activities for both, prospects and current student athletes, where, the coach was just, the former coach was just handing people bags of cash, just things that, really do, it's exactly, I think when we look at those initial sort of NCAA statements on impermissible pay for play, I think that you couldn't get more blatant than some of what the Tennessee coach and AD were doing. Again, they're all gone now. But in any case, the university was under investigation for a few years of this, and they had some pretty harsh penalties. They had an $8 million fine. Scholarships were reduced, recruiting visits were reduced, they're on probation. Just a ton of stuff came out of this. And I think the flip side is Tennessee would probably say a lot of schools are doing that. Just because we did it and got caught, that's happening at a lot of places. We're not an outlier. But that's somewhat irrelevant to what happened. They did get caught. The NCAA did this big investigation, put out these penalties. So fast forward to January of this year, and the NCAA came out in January and said, we are going to be investigating Tennessee again, as well as their collective, the Spire Sports Group, and for improper inducements in recruiting. And so this is a lot of allowing recruits to possibly fly on private jets to visit Tennessee, things that were, again, more in the inducement as opposed to, as I said, the bags of cash that were being handed over. And so Tennessee obviously knew this was coming, and they said, that's cute. No, you're not. And they joined voices with Virginia and filed this suit in the Eastern District of Tennessee, saying that all of the NCAA's NIL interim policies have been slapshod and that they are a violation of the Sherman Act and they're unreasonably restraining trade. So they sought a TRO. They actually did not get the TRO. But they did get this preliminary injunction, which is a big deal. So the preliminary injunction is extremely broad. And this really applies to the NCAA and their activities with recruits. And so that includes both high school athletes and prospective transfers. And so we talked about this a little before, but as the rules are right now, or as they have been, you can't talk to a collective before you've actually signed to a school. And so these AGs are saying that's kind of like you are searching for a job, you're looking at multiple offers, and you can't negotiate your salary or anything until you have an accepted offer, and then you find out. And so, and they think that's unfair. And so I think that, again, the Eastern District of Tennessee thinks they have a point. And we'll see what happens there. But it's a swiftly developing thing. And I think the transfer portal, again, we talk about it, and I think it's become of more significance in recent years, but with NIL, it is because also for a student athlete, you could enter it, you won't lose your scholarship for that year, but if you don't get, a better offer somewhere, you could have really sort of screwed yourself over too. You're there, but maybe your scholarship at that school is in jeopardy. And so, and all of the sort of potential NIL deals you might have had, those may all go away too. This happens to student athletes all the time. And so it's I don't know how much this will be focused on in future briefing, but it is something where they don't know their market valuation. And it is important for them to understand where they stand in that market in relation to other schools. It shouldn't be the only thing that's, spurring you onward, which I think is the sort of con side of things that, how is this so different from pro sports if it's all just focused on where the money is? There should be some sort of educational tie to why you're wanting to transfer. But we're going to see this play out in Tennessee. And so, as I said, Tennessee has had this percolating for a few years, but from what I've read, it's extremely popular in the state that the AG brought this suit. People were very angry about everything that happened with Tennessee football. And again, we're seeing more and more of this with AGs bringing these suits and joining with other states, which is a little atypical. That wasn't what had happened. All of the California suits that really brought Alston to a head, that was former student athletes doing that and forming a class. So this is a really different thing where it's just shifted entirely and become a lot more political.
Yeah, I think you're right. And Sydney, do you have any thoughts as it relates to the portal? Deion Sanders is on record as saying that college football right now is just unrestricted free agency. You get to jump around, move around, and other schools are dangling, NIL dolls in front of them. You have any thoughts as it relates to it?
Of course I have thoughts, Ron. I was waiting for you to ask. No, it's really interesting. We saw just this past week that some college coaches have decided to cancel their spring football scrimmage matches type games, their showcase games. And a lot of them are saying, "Oh, we just don't feel like we need to all this." But there's this undertone that those games were scheduled ahead of the transfer portal opening, and God forbid someone sees some talent on your team and offers something slightly better than what you might have at your school. And so we're kind of seeing this really interesting edge on competition between these schools that maybe they didn't really have in the same level beforehand. And one of the things that I think is really interesting as it comes to transfers as well as recruitment is something that Libby brought up. And that is that we see this all the time in other places when it comes to talent. Like if you want a candidate who is the most talented, most intelligent, best person in Microsoft Excel, of course you're going to offer them a few more perks, a better salary, things like that, because you want to induce them to come and work for you. And so that's not something we ever turn our nose up at when we think about these in other industries and in other areas of work. However, when we think about looking at college athletics, we are still really clinging to this idea of the importance of amateurism and the importance of breeding healthy competition among these schools. And so a big question that I've been struggling with is, on the one hand, we want to allow these athletes to be able to engage in thoughtful and substantive negotiations in order to get themselves the best deal, because we want to see them succeed and we want to see them have those opportunities. But on the other hand, are we willing to forego the importance of having competitive schools that have competitive talent, that have even space teams, so that we have a really good college sports season to watch? Is that something that schools, leagues, and athletes want? And as we kind of figure out what are the anti-competitive and antitrust contours of NIL policy and how they affect the transfer portal and recruitment, we're going to have to come to this boiling point of what does it mean to have competition in college sports? What are we willing to give up, and what are we really needing to protect?
No, that's all super good. And I don't want to pick on Nick Saban, but Nick Saban,
You are.
I
You
know,
are.
right?
You're
I know,
very
right?
anti-Saban.
Yeah, but he literally said one of the reasons for his retirement was when he has conversations with student athletes, they have two questions. How much am I going to play, and how much are you going to pay? And this idea that that's somehow, I don't know the word I'm looking for, sacrosanct to actually be open and honest about, hey, this is what's driving my decision to come to Alabama. Well, I had good playing time, and how much is team willing to pay me? So super curious, and this is something we should all just keep an eye on. So, and so I have to, preface this title, this particular slide with, as the father of a daughter, I just think it's super cool that right now some of the marquee players in collegiate sports are the ladies. I just think it's super cool, whether it's Libby Dunn, whether it's Caitlin Clark, whether it's Flage, Angel Reese. I just think it's super cool that the ladies are truly, truly benefiting from NIL. And so Libby and Sydney have kind of talk us through this particular slide right here.
Sure. So this really again goes a lot back to the collectives. Everything as you've heard today really goes back to these collectives. But so Title IX as was meant to establish gender equity. So when we talked about the collectives being affiliated with the university, they are technically not subject to Title IX. And so this is coming up for a lot of debate right now. So because a lot of the NIL deals are clearly going to these profit sports. So men's basketball, men's football, and to a slightly lesser extent, women's basketball. So where does that leave women? Where does that leave Olympic sports? It's a huge issue. And so this is a question of where we go from here. And, as I said, when they say an investigation is happening into a collective, it also means the university. This line is very blurry. And so whether or not Title IX should apply to a collective and, what that means for these sports, because my understanding too is, if you're donating to the collective, like, you have a lot more control over where your money is going. You're saying, I'm giving it because I want you guys to get the best quarterback possible. Whereas if you just are donating to the university, that could go to any number of things. You could earmark it for something specific, but not in the same way where where a collective's money is going exactly. And we know it is going to mostly, as I said, men's football and basketball. And so it's a question too. I think even though, we see these wonderful candidates like a Caitlin Clark or Angel Reese or, again, Libby Dunn, who have made just incredible strides for all of them, then there are so many other athletes who are just not getting the same opportunities. And part of it is just based on their gender. I was reading something the other day about the Harvard track team where they'll always approach the men first, and so for these deals, and you really have to try and fight for them. And so that's something that I think is just a developing issue that we're going to see, again, as the collectives, this is all, we make it sound as though this is all the way it's been forever. These are all such new things. Obviously, when they even first conceived of this, no one had any idea all of these collectives were going to pop up. And so I think that as it, there's the hope that the market will right itself. And I think, Sydney, you and I talked about that yesterday. I'll let you talk about that, just about, the effect of all of these women athletes and women's sports. And, maybe the market can just self-correct too.
Right. And that's one of the really interesting things as we're thinking about Title IX, NIL, and this question of gender equity. Some of the top earners in NIL right now are really recognizable college women athletes. And so as we think about that, we have to think about it in the broader context of what's happening in the sports world generally. And that is there's a lot of money going into and being invested into women's sports more generally, more than there ever has been before. And that's because the investment potential is huge for women's sports right now. We're seeing an incredible increase in the number of people who are aware of professional women's sports and are interested in professional women's sports. And so as we couple that with the upcoming college athletes who are going to add some more energy, life, and interest into the professional sports world, we have to understand that the money is on the table and there is a lot of money there. And there are a lot of people who are interested in investing. I mean, from just the NWSL, we saw an entire group of owners who own their own soccer team. And they specifically did that for a women's soccer team because a women's soccer team was worth investing in. And so as kind of these people who hold the purse strings, as advertisers who have a lot of money to kind of spend and dish out in certain areas, the potential for women athletes to take a huge sum of that money is there. It's already happening in so many places. And there is a potential and a possibility that these women athletes are going to be able to take a lot larger of a sum than maybe they had been in the past. And so there is kind of this almost market correcting that's happening right now as we're seeing these women athletes really be much more in the limelight than they ever have been in the past. And a big part of that is thanks to kind of the NIL that they've been allowed to participate in. And by growing their brand and their identities, they're also doing themselves and their sports a huge favor by bringing a lot more attention, because once attention brings more attention, brings more attention, brings more advertisers. And once most advertisers have an idea that these people are worth investing in, the money follows suit and money talks. And ultimately, if money is going to women's basketball, women's volleyball, women's soccer, we're going to see a lot more interest and a lot more investment in those places because money becomes money.
Absolutely.
Yes, I talked about this yesterday. Everyone on this should know that the fastest growing sport is actually women's volleyball. So like collegiate space, so there's a lot of upside in women's sports. So yeah, that's the hope that things just keep on that trajectory.
Absolutely. And we have to mention the fact that I don't know if it was last year, the year before, Nebraska's volleyball team played inside of a football stadium and 70,000 people attended the ladies volleyball game. So it's just super cool. Super cool. So, all right. So we have to talk about the Dartmouth men's basketball team. Again, I'll make sure I preface this with I am not an L&E attorney. In fact, I see in the webinar chat that all the L&E attorneys already firing, messages as it relates.
They're letting us know. They're letting
Absolutely.
us know.
Yeah, exactly. So they're already firing off, questions, or just they want to talk about the Dartmouth men's basketball game or its basketball team. And so let me just kind of set the table with just some super basic stuff as it relates to the National Labor Relations Act, the NLRA, which is a federal statute that allows private sector employees the right to unionize, collectively bargain. And then we can kind of talk about the National Relations Labor Board, which was created by the NLRA. And this kind of think of it as a quasi-judicial board that makes determination regarding employees' rights to unionize and collectively bargain. And so now we can go to the Dartmouth men's basketball slide and talk about what's actually happening there. And what on February 5th, 2024, an NLRB regional director, kind of think of it as like a trial judge, ruled that the players were employees. And so once that happened, on 3/5/2024, the players voted to unionize with SEIU Local 560, a union that already represents hundreds of workers at Dartmouth, in particular the food service staff at Dartmouth. And on 3/14 of this year, the NLRB regional director certified that vote. And so now what's going on with Dartmouth? The school has refused to negotiate with the men's basketball team. But we can let me back up, just talk briefly about the decision as it relates to why the NLRB made a determination that these are employees. It goes to this idea that the Dartmouth has the ability to control a substantial amount of time about how the men's team goes about their day, so to speak, this control element. And typically when we think about these cases, we think about we think about the Northwestern case a few years ago, probably 10 years ago, whereby Northwestern and its football team wanted to unionize. However, the NLRB said, no, not in this instance. And one of the reasons they gave was that the Northwestern football team, Northwestern being a private school, that would have potentially impact on other state schools inside of the Big Ten. And so too many issues as it related to that. But now we have the Dartmouth men's basketball team. They're in the Ivies. All of them are private schools. They're all similarly situated. And so it's my theory that this was a ripe opportunity to say, nope, this is where we make a determination that these are employees, they can unionize. And now this horrible pun, the ball is in Dartmouth's court right now. What do you do about this? And so, Libby, Sydney, any thoughts about Dartmouth's men's basketball in LRB?
Again, as I think we all want to heavily caveat that we are not labor and employment lawyers, because this is really just a developing issue. And, again, one of our colleagues, Eric Barnum, made a comment in the chats to us, which is correct that, even though this would create a huge headache for schools, where do you owe them all health care? Like, where does this all work now if they're employees? Like, if you don't get enough playing time, do you get to file a grievance? Like, how does it work? But if you really care about sort of creating a universal NIL landscape and maybe bringing this Pandora's box a little bit more in, unionization would be one way to do that. It would kind of destroy a lot of the collectives because it would have, the effect of, sort of mandating parity. So that's one. I thought that was really interesting when he made that point, and I agree with that because I think from my perspective, looking at it as, again, not an expert or practitioner, I've only really thought about some of the more practical things of how would that work when you think of an employee-employer relationship. And, that's probably, hopefully, wiser labor minds than I are advising all of these schools as they deal with these issues. And there's another case pending on the West Coast too on this. This is, again, all of these things are just percolating everywhere where people are trying to decide what is the right path forward.
And I think that this case is a great example of the fact that this is an area that is ripe for cross-disciplinary approaches because we see all of these different issues that are really in conversation with one another and they cross a variety of different practices. And it's just so necessary to continue to have those conversations that kind of reach across different practice areas to adequately and sufficiently address these many, many issues.
Yeah, I think you're right. And I think in order to do this particular side justice, we need to have either another webinar or a podcast and bring on our L&E team. That's Pat Muldowney, Eric Barnum, Todd Leibowitz, and just really truly have a conversation about what's happening in sports and collegiate sport as it relates to this employment element, because I think this is one of the largest pieces right here. We talk about the antitrust piece all the time, but I think the emergence of student athletes as employees is absolutely huge and critical to any discussion about NIL and what's going on. So I know we're running short on time. We only have 5 minutes remaining. So I'm going to have, Sydney, Libby, if we're drafting, like top issues, legal issues in collegiate sports to watch, what do you think is one of those legal issues that the attendee should keep an eye on?
I can definitely start with mine is that I think something that I would really like to see happen over the course of the next few years is really seeing collectives kind of take an eye towards the equity conversation that we are having when it comes to women's sports. I wouldn't be surprised if within the next few months, or perhaps taking a note from this little mention that I'm going to make now, we see a collective that's entirely focused on supporting women's athletes across all different kinds of sports. I think that it's an entirely viable investment, and I wouldn't be surprised if that were to happen. And I think that's something that we're going to continue to talk about, is this question of equity and this question of how we can respond to issues with regards to making sure that women athletes are supported in the same ways that their male counterparts are.
Gotcha. Libby, what are your thoughts?
Again, I mean, there's just so much here, and there are so many things that we talked about. There's so much that we didn't even get to talk about. We talked about beforehand, just international students who most people on this call probably don't know that, but they're not allowed to take advantage of any NIL as part of their deal with playing sports in America. So that's just like a wholly side issue we didn't even get to, as well as all of the various L&E stuff we got to at the end. From my perspective, I think the things to watch are really these cases in Tennessee and West Virginia, see how that affects, the NCAA's enforcement capabilities. As we move forward, because obviously that's seriously curtailed. The investigation that they did have going is obviously paused forever, and as are any others, and whether or not they get any of that back, and how they react in other ways when we see these other, more blatant pay for play schemes that don't even, go through a collective or have any of that veneer, that are just, people handing over cash. Because another thing that was interesting that I didn't mention then too is part of that injunction is the NCAA cannot retroactively punish, which they have been known to do in a lot of cases. When something comes out, they're like, oh, guess what? Now you have a big fine. Now you're banned in the off season. So that has been taken away from them too. So just seeing where the organization goes from here is going to be something for everyone to watch. And, it sounds dramatic, but does it even exist in 10 years? What happens? Do the conferences just take over?
Yeah, and I think that's a nice little kind of like transition for me, as I think we should keep an eye on conference realignments and the media deals and how the business of collegiate sports begin to dictate the structure of collegiate sports, meaning, what's going to happen to the Pac-12? It's like a Pac-2 now. What's going to happen to the Big Ten and the SEC is they begin to grow and become the dominant conferences as well. So that's something I think.
You didn't even get there.
Yeah. Yeah. And one of the things that I think we should truly keep an eye on is the idea of, you mentioned it, Libby, the sheer number of antitrust cases that are pending against the NCAA right now. And I suspect the damages are in the billions of dollars if these antitrust cases are successful. And if they are successful, what posture does that put the NCAA in? Are they in a settlement posture to begin to fix and begin to curtail and change rules? Does it go away? Does college football break off and do its own thing along with some of the other sports? What just truly happens? And so, again, if you are a sports nerd like the three of us, this is a super, super interesting time to be following collegiate sports. And kind of with that, I think we are out of time. And the last thing I will say is I can guarantee you no one on this call or the attendees has a perfect bracket right now after Oakland. So with that, we will wrap up. We appreciate everyone attending, and be on the lookout for additional webinars in the sports space. We look forward to presenting again and offering up some insights as it relates to collegiate sports, but also talk about BakerHostetler and our sports industry team and all the work that we do in this space. So we appreciate everyone for attending, and we look forward to the next one.